to start with three words which are in the title: update and restrictive covenants. Probably the nastiest words that we've come across today. Why is it that the law schools put us off restrictive covenants and they're treated with the same horror as perpetuities and the rule in Boosh and Sproul? I don't know, but let's try and make it easy. And secondly, the word update. A chap comes up from Lincoln's Inn. He's going to talk about an update on restrictive covenants. Well, am I going to start nearly a century ago on the 1st of January 1926? Or even before then? No, I'm not. Update, restrictive covenants. Why do I need reminding? And the word is stress and reminder. Why do I need reminding of certain things in the law of restrictive covenants? Now, I'm assuming you're all familiar with the basic stuff and you deal with it either in non-litigation reports on title or litigation or whatever it happens to be. And they are tricky and it can be complex. But do we need to be unnecessarily frightened of it? Why are we afraid of it? And is there anything we can get to overcome that fear? A bit like fear of flying, you can go on a special course, etc., etc. If we think about the law of restrictive covenants, it's a mixture, but not an alloy of three things. It's not an alloy, it's an admixture. And anybody who's thought of vinaigrette dressing, or indeed perhaps even a more advanced idea might be hollandaise sauce, it can fall apart if you don't mix it properly. But it's still slightly what a physicist might call an unstable solution. It's a mixture of three things, and this is where it starts to get simple. The common law, the Court of King's Bench, one end of Westminster Hall, the law of contract. The covenants are only really contracts. I offer to pay you a fiver, or I agree to pay you a fiver. That's a contract. I agree not to put a glue factory on my land. That's a contract. The simple fact that it's under deed and therefore, according to the lawyerly fraternities, it's a covenant doesn't mean it's any different. And therefore, in restrictive covenant law, we've got original liability under contract. I agree to pay you a fiver. I'm still liable. There might be an assignment of that agreement, in which case that might be a valid assignment, and rarely you sometimes get assignment of the benefit of covenants, not often. And also, just remind ourselves that the benefit, the right to enforce a restrictive covenant, passes at common law. So that's important. So common law, big bit of the jigsaw. Second ingredient, as in the recipe, it might be the mustard or it might be the vinegar, is equity, the other end of Westminster Hall. The Lord Chancellor and his proverbial foot, and the remedies. And this is where we get to the running of the burden. Tulk and Moxhay, we may remember, 1848, the year of revolution, 22nd of December 1848, Lord Cottenham granting the injunction to restrain the development in Leicester Square. And that has its own history, which I can't develop today, but there it is in some of the books. You will learn all about Tulk and Moxhay, Baron Gottheimer, and all sorts of links to this, that, and the other in Leicester Square in London. But that was, of course, the famous creation of bona fide purchasers being bound by covenants of which they had notice. And the other correlative to this is, of course, remedies. Despite the fact we're now 150 plus years, 160 years past the Judicature Acts, we've still got the concept of the equitable remedy, the injunction. We'll come on to that in due course. And the final bit of the ingredient of the recipe is statute. Now, statute actually hasn't really changed much of the foregoing. It's common law and equity. Statute is a bit of an add-on, because what we've got is the 1925 legislation coming up to its centenary nearly. We've got Land Charges Act, blah, 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 Land Registration Act, now just 21 years old nearly, almost attained its majority. And that's that. But there's no fundamental reform of the way in which covenants operate, save that, of course, to be valid and binding, there is, of course, now a registration system as opposed to the bona fide purchase of value, which is equity's darling. Imagine this is a play. This is going to be a very simple, Ratigan-like play, separate tables or sitting all together in one room, whatever you want to call it. The first part of the play is looking at the common law. Act 1, Scene 1, early morning, the common lawyers come in and develop their speeches about how common law develops or has ruled covenants. The second act of the play is noon. Who can enforce this covenant? There's a big question, case I will be coming to on that. And that's where you have the equity lawyers coming onto the stage and saying, this, that, and the other, burdens, blah, 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 all the other things. And we have, at the backdrop to our stage, picture of Leicester Square. And for reasons I'll explain in a minute, the Bath Rugby Cup ground in Bath. Act 3, early evening. What's the remedy? Here we have the stage judge sitting in Banco and the equity lawyers saying it should be an injunction, and the common lawyers saying, oh, no, it should be damages. And we look in a moment at the remedy of the injunction. And then the final act is night time, where the parties to an upper tribunal lands chamber case are all suffering sleepless nights and nightmares because they can't agree on whether the application should succeed or not. And the poor experts are having an absolutely sleepless night and waking up in a muck sweat at 3 a.m. because they can't remember what YP it is or whatever it is happening to the valuations. So that's the context in which I'm going to present the talk today. Act 1, the common lawyers. What does this covenant mean? Now, this is the thing that gets forgotten. It's the first thing we often need to look at, words. And I am going just to mention one case, which again is all in the paper, you can read it at your leisure, called Mackenzie and Chung, which was all about the construction of 3 words, as they're always short, in a covenant entered into in the 1940s by the Whitgift Foundation in Croydon in South London. Now, the question there was whether the words in the power to release, which were in terms of having the power to, or having the right to allow a departure from the covenants, allowed the foundation, which was one of the beneficiaries, or the principal beneficiary of the covenants, to agree a release with Miss Chung, who owned the development site. This was in Selsdon in South London, just south of Croydon. Few properties up to the north was Mr. Mackenzie, and he said, no, that can't work. I want to enforce this covenant, and you're going to be in breach of it because it's a single private residence, and you're going to put up a block of flats. Question, who was right? The master said Mr. Mackenzie was right. Mr. Justice Miles said Miss Chung was right, that the power to release did allow a departure in the sense of the proposed release that Miss Chung and the developers were going to enter into with the foundation. Court of Appeal agreed with Mr. Justice Miles. And the importance of that case, if it doesn't have wide importance, but it has importance in the context of the advice we give in restrictive covenant law, is that it reminds us once again, 9 and a bit years after Arnold and Britain, that we do need conscientiously to go through those principles that are set out so clearly at paragraph 15 of Lord Neuberger's judgment. And I've set that out in the paper. You don't have to look at it now, it's there. And my view is that I try to keep it in mind. And in fact, I was doing something on the train up today. Always have those words in front of you and then interpose the words that you've got in your case so it makes practical sense. That's all you need, really, all those lines. Now, there have been lots of cases since then, levels of court, including the Supreme Court, Wood and Capita, etc., etc., etc. But my view is if you start the approach by working out what does this covenant mean, that's the first thing. And the Scylla and Charybdis is that if you don't do that, you may be advising that there's a breach. And actually, if you were to look again at it, go home, come back the next morning, and then walk around the square or whatever, yes, this is arguable. Not daft arguable, but arguable. It may not be that there's a breach. I'm looking at something at the moment where there's a bit of roadway construction, just a roadway, tarmac and a bit of curbing. Is that an erection? That's a big question, really, isn't it? If you're constructing a roadway, is it an erection? I don't personally think it is, and there's some case law which says it isn't. But again, you look at those words in the context. So that's Mackenzie and Chung, and I'm not going to say any much more about that. In the paper, there's a couple more recent cases, Reeve and McDonough, about whether you could pull down a house and rebuild it within or without the covenant out at Poole Harbour, and another case decided a couple of years ago about nuisance and annoyance covenants, which is another great subject, which sadly I haven't got time to do today. So part one of the jigsaw, Act 1, Scene 1, etc., is have we interpreted the covenant properly? Now, that's just part of general law. I mean, you could be an expert on charter parties or mining or whatever, insurance, all the things that we often do as civil lawyers. Don't need to have a knowledge of restrictive covenant law to work out the meaning of words in their context. That's always the starting point. And my view is don't get sort of blinded by these ghastly half-legible entries in the official copies going on for page and page and page. You just think, hang on a minute, these words in their context, what do they mean? If you've got to that part, and if you've kept awake during the first act of the play, you get to the second act of the play, which is who can enforce this covenant? Let's assume there's a breach or likely breach, and we then have to ask our question, who's going to be able to enforce it? Now, reminders again. You're probably all familiar, because it was coming up for 3 years ago, can I believe it? Bath Rugby, decided just before Christmas 2022. Bath Rugby and Greenwood, which is the case, I've summarised it briefly in the paper, about whether or not Bath Rugby were going to be in breach of a nuisance or annoyance cause, or more likely whether the owner of some property at the end of Great Pontney Street, facing the Bath Rugby ground, if any of you know Bath, the Wreck as it's called, whether Greenwood and others, the owner, ultimately it was only just two defendants, the 7th and 8th defendants, lessee and freeholder of the property at Great Pontney Street, whether they could enforce the covenant. His Honour Judge Matthews said they could at Bristol. Court of Appeal said, no, you can't. And the reason for that is the big question, the big tricky question that we have once we've got into Act 2 is, what is the evidence of successors in title of the original covenantee being able to enforce this covenant? Now, again, we may remember from not just our work, but our law school days, etc., we're often blinded by pages of stuff on assignments, building schemes, chains of assignment, blah, blah, blah. No, forget all that. That's usually unusual. It's annexation. What is annexation? Annexation, I often say, is a bit like gluing the carpet down and making sure it stays there, the benefit being the carpet. Have we got words expressly, or do we have implications from circumstances, in other words, or can we rely on some admissible evidence to show the land intended to be benefited? In Bath Rugby, there was only a reference to the Bathwick estate, and the nuisance and annoyance covenant was certainly held, contrary to His Honour Judge Matthews' judgment, not to affect annexation, even though it referred to people in the neighbourhood, etc. So you do have to then start going through that process. Where are the words of annexation? If they're not there, how can I imply annexation? Of course, we have a watershed between the 1st of January or 31st of December 25 and the 31st of December 25 and the 1st of January 1926, where we have before and after section 78, but those words in that section are the land intended to be benefited, still very important, ultimately in identifying the land intended to be benefited. In this context, we're often faced with clients who will say two things. One, well, I've got planning permission. Well, forget that. We won't get into that today, although it does not come into remedies. Secondly, you'll have a client who will be owner of Monabri, if it's not called Moonraker, and they will say, oh, but the covenant's on the developer's land. It's there, it's on the title. Yes, but the question is, can you enforce it? And that's the tricky bit, and that's where you do the detective work, fortunately these days with open registers, etc. What's the order of conveyances of? What are the words of annexation? Are there any words of annexation? And I view Bath Rugby as the most important, well, important is a relative term, the most useful recent decision of the Court of Appeal on the question of annexation and identifying the benefited land and who can enforce a covenant, really, since a long time ago, like 40 years ago, Federated Homes, 35 years ago in the 80s. So that's all I'm going to say about Bath Rugby. So far, we've kept ourselves interested in the play through Act 1, which is what does it mean? Act 2 is what evidence is there as to who could enforce this covenant. I mean, ultimately, if you stop there, you're acting for a developer client, no evidence of people could enforce it, but there's sort of ruffles, especially planning objections. Well, let's go and see if we can get an indemnity policy, provided there's no bars to that. But that's the point at which you could say to them, yeah, I think we've got a good case for an indemnity policy. Here's young Francis's opinion on a non-reliance basis. Also, I haven't got time today to say, well, there might be nobody enforcing because of unity of title and other things that might mean the covenant is worthless. Let's then get to Act 3. Let's assume there's an interval with lots of champagne before we get to Act 3. We come in mildly tiddly to see the actors fighting it out in front of the stage judge. Maybe Malcolm should be the judge today, and we'll have an argument about should there be an injunction? What is the remedy? Depends who you're for sometimes. If you're for the developer or the party who's going to be in breach, they will say, well, I've got planning consent. Sorry, no answer. That's the wrong answer. It doesn't give you the answer. Well, this is a mere little pimple on the landscape. It's nothing. Hang on a minute. 10 and a bit years ago, the Supreme Court in Fen Tigers reminded us that the injunction is the primary remedy. Think injunction. That sign you sometimes see, I saw it a couple of times a day when I was idly looking out of the window on LNER, that sign on the signals. They say, watch out for a red light, or it's some sign to railwomen. Don't jump this light. Think the red light, think the amber light. Now, this is 10 years. This is hardly worthy of an update. You're probably thinking, well, he's talking about updates. This is 10 years old. Well, hang on a minute. Let's just think about this. I'm going to ask myself the question, why do I mention this? Because it gets forgotten. And this is why I mentioned earlier a reminder. It's a reminder to us to remind ourselves and remind our clients that the injunction is the prima facie remedy. Of course, it's equity, and the court has a discretion. What is the just, what is the proportionate remedy here? Should there be an injunction granted? at what time has the injunction been sought, quia met, and all of that. Post-breach, should there be a mandatory injunction to pull down? I was last here a few years ago in the moot hall arguing against, I'm afraid, a pretty good case for an injunction in mandatory terms where my clients had ridden roughshod over some covenants and blocked out a chap's view in the countryside some way from here. I'm afraid that was a bit of a loser. So there you have it. You have the problem that you need to ask yourself the question, what is the remedy? And the case that I have referred to in my paper, it's not a terribly well-known case, and it's a case of some instruction on two fronts, really. It's the case about a rather high-class estate in leafy Surrey, not very far from Kingston upon Thames, just off the A3 if you're shooting down to see the Navy at Portsmouth. Won't see much of the Navy at Portsmouth these days, but anyway, that's another story. The Ridgeway Oxshot against McGuinness, and that was where the McGuinnesses wanted to develop their plot in breach of effectively a user covenant that was combined with the easement. So the rights of way over the private roads were tied in to the observation of the covenants on the plots. And His Honour Judge Monty, KC, said there was going to be an injunction. So he granted the injunction in that case. And it's worth just diving into that. It's quite I wouldn't say the word interesting, but it's quite a useful read for those of us who just need to look at some of the ways in which the judges are looking at the grants of injunctions. Also, it's very useful if you're thinking about covenants, especially imposing covenants, which you may do, or building scheme, not building schemes in the covenant sense, but developments, have a think about combining the easements with user. Because as you all know, we're just about to go into it, the Upper Tribunal Lands Chamber doesn't have any jurisdiction to modify easements. So there you are. Much more cast iron than a restrictive covenant. Act 4, you will be relieved to hear the final act. The Upper Tribunal Lands Chamber. Well, what can we say about that? I think there are three things that are important when you're considering this jurisdiction, and it may be the answer from the audience gives me the clue to the first point. If you're not familiar with this jurisdiction, be careful, because it is highly specialized, and I think with huge deference to all your experiences and everything else, I wouldn't want to start, a bit like the Irishman, wouldn't want to start from here without any experience of it at all. But we all know as lawyers, we have to get our pips onto our shoulders somehow, so it may be we've got to get to grips with it. So in a sense, what I'm going to say in the next 2 points is really getting to grips with some of the fundamentals, which can get lost in sight when even some of us who do a lot of this work are dealing with it. The first is that this is adversarial litigation. And you may not be litigators, but you may often have to advise on title or advise clients on their merits of things. And upper tribunal applications to modify covenants are adversarial. They're not inquiries like coroner's courts or anything like that. Just standard adversarial litigation, like any civil litigation that you have. Therefore, the first question is on whom is the burden of proof? Burden of proof is on the applicant. He or she is already one goal down because he's got the covenant on him or her. Therefore, to score, he or she's got to score 2 goals, or rather to win. A draw is not enough. That's the first thing. The second thing is you have to use what we might call as lawyers admissible evidence. That's not just lay evidence, but with the permission of the tribunal, expert evidence. And what counts there, and it's a point you will see when you read my paper, is the detail counts to the finest degree. There's no use, not that you would anyway, but I have seen cases where it's mudge and fudge and fuzz and foam. It's not going to cut it in that jurisdiction. It's very, very precise. Any of you who have ever seen those documentaries about London cabbies doing the knowledge and going in for their appearances. Anybody ever seen any of those? No? One? Yes? They will ask you, if you're the bloke who wants to get, or her bloke or blokeess who wants to get the badge, the chap will sit there across this great map and he'll say, right, Mansion House to the Poor Society of Widows and Orphans. And they have to get it absolutely right across London within the green badge area. And that's the level of detail that we need in our applications to the tribunal. There are some points, my third point is, apart from those generalities, there are some points which need specific attention, which get lost. One, does this case involve a restriction as to the user of land? And that's where it gets tricky, especially when, because we sometimes forget, we're engaging the landlord, the leasehold jurisdiction for leases that qualify under subsection 9, and that's very important. Don't forget that. And there was a trio of cases a few years ago. They all came along, a bit like London buses or a bit like London cabs, all together after many years' absence, and they're noted in my paper. Don't forget the exclusions. I was dealing with something on a former airport, and airport land and Ministry of Defence land and some other lands is excluded from the jurisdiction, so don't forget that. National Trust inalienable land, similarly. Think about double hatting. What is double hatting? That's where you've, say, got a question about the covenant restriction, you've got a question about an injunction, which clearly the tribunal hasn't got jurisdiction to grant. You then think to yourself, well, how do I pull them together? And by judicial management, or whatever the word is, deployment, you get both the upper tribunal application, modification application, heard at the same time as the injunction or whatever. And I was in a case a few years ago, referred to in the paper, called Collins and Howell, where we did just that. And that's useful because you then have the whole thing dealt with. So you have what we call a Section 9 judge and a member of the tribunal. So you have a Section 9 judge and member of the tribunal will deal with the upper tribunal bit, and the Section 9 judge will deal with the injunction or declaratory remedies or whatever. Watch out for service of documents and orders. This actually could apply outside this jurisdiction. I wrote an article in the Landlord and Tenant Review, which sometimes you see in August, where there's reference made to a case called Black Horse Investments and Southwark London Borough Council, where all the service and everything else went completely wrong because of the internal inefficiencies of Southwark Borough Council. And the article is headed, When the Green Light Can Turn Amber, because my clients thought they had the benefit of this order to allow the conversion of a pub into some flats. No, they didn't, because the whole thing hadn't been dealt with properly, not quite by the Lands Tribunal, but certainly through Southwark, etc., as the objectors. So, and again, I noticed there's been recent cases about late filing of documents in civil litigation. Master Clerk, I think earlier this week, refusing leave in a Part 8 claim for extension of time, blah, blah, blah. So we've got to be very careful about that. And then one final point, which is terribly important, and you may see this even if you've not been involved in Lands Upper Tribunal jurisdiction cases. In the Upper Tribunal, compensation is either an unusual cases where the price paid for the land reflected the diminution caused by the covenant. That's what we might call a paragraph 2 case, quite unusual. More commonly, it's a sum to make up for the loss suffered by reason of the order, and that's paragraph 1, or little subparagraph 1. That compensation is only assessed on the basis of diminution in capital value, and not on the basis of uplifts, percentages, Stokes, Morris Garner, and all the other stuff, negotiating damages. Now, if you're in a smoke-filled room arguing for a release or modification of a covenant, or at least arguing, having a discussion, having a mediation, blah, 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 some attempt to settle the matter, you will then need to remember, if you're in a covenant case, the expectation must be trimmed. The expectation of the party with the benefit of the covenant must be trimmed by the fact that if if you went to the tribunal, they lost but got compensation, that compensation would not be negotiating damages. So that's one trim. The other trim is costs. In the tribunal, again, a special rule, if you win, you've got to pay your own costs unless the other side have been acting unreasonably. If you lose, of course, as an objector, you won't be paying the applicant's costs, but if you lose as an applicant, then you will be paying the other side's costs. Now, that's slightly different, at least in terms of the winning applicant from the CPR. So that's very important to remember that. And again, in the smoke-filled room, I do advise people to bear in mind, when we're looking at the money, one, what would the Lands Tribunal do? And two, where would we be going in terms of costs? And these costs are expensive. It's well into six figures in anything of even the minor substance, unless it's all agreed, etc. So, ladies and gentlemen, I hope that is the end of Act 4. I hope that that wasn't too much generality. It was an update in the sense of 4 parts. Thank you very much, ladies and gentlemen. Thank you.